My name is Josephine, and I am a student at John Jay School of Criminal Justice. I created this video for my summer class 2013 entitled Security of Information and Technology, which is taught by Professor Adam Scott Want. The case I will be discussing is the people of the state of New York, the plaintiff, versus Victor Garcia, Rafael Morel, and Kennedy Tabares, the defendants. County Court of Westchester County, New York, dated January 11, 1996. At one time, cloning of cellular phones accounted for a large portion of cell fraud. Here, we have a case whereby evidence showed that the defendants were observed by a police officer on patrol as they sat in an automobile in the parking lot of a train station. The officer saw them move from one parking space to another, sit for a time, and then move to another space. When the three eventually left the car, the officer approached and asked what they were doing. Upon receiving conflicting responses, the officer sought and obtained from defendant Garcia consent to search his vehicle. Search revealed hidden under a floor mat beneath the car's dashboard a radio scanner and a digital audio tape recorder, as well as a cellular telephone on the rear passenger seat. When asked the purpose of this equipment, the officer was told that they thought it was fun to listen to police radio communications and that they had been taping the conversations. The officer ultimately took the defendants into custody and impounded the vehicle. The investigation proved that the scanner had been programmed to receive coded information transmitted on cellular mobile telephone frequencies. The digital audio tape equipment was found to have been connected to the scanner and contained a tape recording of encoded information transmitted on various channels dedicated to cellular communications. Among the recorded information were the serial numbers and code numbers of cellular mobile telephones. Based upon the evidence, the grand jury returned an indictment charging the defendants with criminal possession of a forged instrument in the second degree, eavesdropping, unlawful duplication of computer-related material, criminal possession of computer-related material, possession of a police radio frequency scanner as a violation of Vehicle and Traffic Law Section 397, and possession of burglar's tools. Defendant Garcia was also charged with a violation of Vehicle and Traffic Law Section 4021 for having his rear license plate insecurely fastened. The evidence before the grand jury was sufficient to support the charge of criminal possession of a forged instrument in the second degree. The cloned computer chip in the cellular telephone found in the vehicle contained encoded computer data. Computer data is specifically enumerated in the definition of written instrument contained in Penal Law Section 170.00 Penal 1. This instrument does or may evidence, create, transfer, terminate, or otherwise affect a legal right, interest, obligation, or status as defined in Penal Law Section 170.10 Penal 1. And the cloned chip was falsely made as that term is defined in Penal Law Section 170.00 Penal 4. Insofar as the evidence before the grand jury indicated that it had been encoded without the authorization of the rightful owner of the telephone number programmed into it. Therefore, the knowing possession of a cloned cellular telephone chip with the intent to defraud, deceive, or injure another constitutes the crime of criminal possession of a forged instrument in the second degree. Similarly, the actions of the defendants in assessing the electronic communications on the cellular telephone frequencies without authorization constitutes the offense of eavesdropping under Penal Law Section 250.05 Penal. The taping of the cellular computer data, done as the evidence before the grand jury suggests, with the intention of furthering the cloning of cellular telephones constitutes the offense of unlawful duplication of computer-related material under Penal Law Section 156.30, Penal 2. This also constitutes the inclusory count of criminal possession of computer-related material under Penal Law Section 156.35 Penal. The possession of the scanner programmed to intercept cellular telephone code information and the possession of the digital audio tape recorder adapted to record these data fit the statutory definition of possession of burglar's tools under Penal Law Section 140.35 Penal. While the legislature may have envisioned such relatively primitive implements as crowbars or lockpicks when it enacted this statute, the definition given to burglar's tools encompasses the sophisticated equipment at issue in this case. These items were adapted for use in furthering theft of telephone services and the circumstances surrounding their use, including the simultaneous possession of a cellular telephone that had been cloned by the use of the same type of equipment as found in the defendant's car. Evidence and intent on the part of the defendants to use these devices in the commission of thefts of telephone services. Therefore, the indictment is also supported by sufficient evidence. Nonetheless, the evidence before the grand jury was not sufficient to support the indictment charging a violation of Vehicle and Traffic Law Section 397, possession in a motor vehicle of a radio capable of intercepting police communication frequencies. The testimony of the electronics expert in the grand jury showed that the scanner used by the defendants was programmed to intercept only cellular telephone data frequencies, while the witness did testify that the scanner could be reprogrammed to receive police communication frequencies. The possession of a radio receiver that could be modified to intercept unauthorized communications does not rise to the level of the crime proscribed by the Vehicle and Traffic. The evidence before the grand jury was insufficient to support the indictment charging a violation of Section 402, Vehicle and Traffic of the Vehicle and Traffic Law. The only evidence adduced in support of this charge was the testimony of the arresting officer that, in quote, the license plate on the rear of the vehicle was on only by a twist tie and usually is put on by screws. This is a violation of the New York State Vehicle and Traffic Law. End of quote. Aside from the usurpation of the grand jury's function evidenced in the latter sentence, as well as its incorrect statement of the law, this charge must be dismissed for legal insufficiency. Section 402, Vehicle and Traffic of the Vehicle and Traffic Law merely requires license plates to be securely fastened so as to prevent them from swinging, and does not mandate the use of screws, bolts, or any particular fastener. Since nothing in the officer's testimony suggests that the license plate was insecurely fastened or free to swing, this count must be dismissed. In sum, the defendant's motion to inspect and dismiss or reduce counts of the indictment is denied as to all counts except for the charge of possession of a radio receiver and rear license plate insecurely fastened. These counts were dismissed with leave to the people to represent to another grand jury should they so choose. On March 2, 1998, the New York Times wrote an article entitled, "Congress Moving Quickly to Try to Curb Cell Phone Abuses." I took a few excerpts from the article as follows. The movement to crack down on cellular phone fraud and eavesdropping is gaining ground in Congress. The cellular phone industry estimates that it lost $650 million in revenue because of cloning in 1996. On Thursday, the House, on a vote of 414 to 1, passed the bill making it illegal to possess cloning devices. Mobile cloning is copying the identity of one mobile telephone to another mobile telephone. The cloning occurs when the account number of a victim telephone user is stolen and reprogrammed into another cellular telephone. Each cellular phone has a unique pair of identifying numbers, the electronic serial number (ESN) and the mobile identification number (MIN). The ESN and MIN pair can be cloned in a number of ways without the knowledge of the carrier or subscriber through the use of electronic scanning devices. After the ESN and MIN pair is captured, the cloner reprograms or alters the microchip of any wireless phone to create a clone of the wireless phone from which the ESN and MIN pair was stolen. The entire programming process takes 10 to 15 minutes per phone. Any call made with cloned phone are billed to and traced to a legitimate phone account. And thus, innocent citizens end up with unexplained monthly phone bills. Cellular fraud is defined as the unauthorized use, tampering, or manipulation of a cellular phone or service. At one time, cloning of cellular phones accounted for a large portion of cell fraud. As a result, the Wireless Telephone Protection Act of 1998 expanded prior law to criminalize the use, possession, manufacture, or sale of cloning hardware or software. Currently, the primary type of cell fraud is subscriber fraud. The cellular industry estimates that carriers lose more than 150 million per year due to subscriber fraud. To prevent subscriber fraud, make sure that your personal information is kept private when purchasing anything in a store or on the internet. Protecting your personal information is your responsibility. For cell phone cloning fraud, the cellular equipment manufacturing industry has deployed authentication systems that have proven to be a very effective countermeasure to cloning. For more information, please visit the Federal Communications Commission's website. That's www.fcc.gov. Thank you.